can you come up here and take a seat, please? No, I'll tell you when the time comes. And this is down to 1. So in this case, an order was previously entered by a different judge. That order remains in place. This comes before the calendar on Ms. Hunt's request to modify the existing order. And then Mr. Stonecipher filed a declaration in response to your request. Did you see that?
No, I was originally going to ask for a continuance because by my servicing company, he was never served. So I'm surprised to see him here today, but happy to take care of the hearing. Okay. So I did not know that he was served.
Well, yeah, he got served. We got the packet late last week. Or no, wait a minute. Hang on just a minute.
If I may, Your Honor, I was never formally served. I received Mrs. Hunt's.
Hang on, we can hear
from,
of course. You're here with an attorney, so I'll
correct. Okay.
Mr. Clark, if you want to address that, you can.
Yeah,
so
he was not formal. Yeah, as he was saying, he was not formally served, but he did learn about this through other means. And Ms. Hunt should have received the declaration. I emailed it to her and I mailed it to her with substantial time for her to receive it.
Did you not receive that, ma'am?
I never received those documents.
So what I think it's only just a one document. It's a declaration in response. Give me just a minute. What we're going to do, ma'am, we're going to print off a copy of that declaration. I'm going to have you review it. Then you can go back in. You can go back into the court. You can review it. And then if everybody's agreed, we'll just go forward on this motion here today. So no one has to come back.
Okay. Thank you, Your Honor.
You're welcome. The Stonecipher Hunt, and then after that, I'll come to you.
Thank you, Your Honor.
So, ma'am, you can come on back up. You can take a seat. So you have asked to adjust the no contact order. In the response that was filed by the declaration from Mr. Stonecipher. Well, I guess having said that, are you prepared to proceed here today? You said earlier that you were.
Yes, Your Honor.
Okay. Basically that there's nothing in this order that prevents you from participating in any sort of investigation, which I think kind of came as news to Mr. Stonecipher, if I understand that declaration correctly. But I'll hear from you briefly as to why you think the no contact order should be adjusted.
Do I need to stand, Your Honor?
You do not.
Okay. So in seeking out legal counsel, I have been directed that I should not talk to CPS or the police or the school district about the allegations that my son has told me concerning 3 educators at the preschool that inappropriately touched him, which he is now receiving trauma therapy for. The legal counsel that I received said that that could be viewed as third-party contact and that I need to go before the court and request that it be modified.
So I'm going to stop you for a second and tell you, I don't view that as third-party contact. Third-party contact is going to them and say, hey, go tell this person this or that. If you're reporting something, I don't think that there's anything in this order that prevents you from doing that. I know that, excuse me. I know that Mr. Stonecipher disagrees with that, but Mr. Clark, I'll come to you. What's your opinion on what I just said?
No, I agree, Your Honor. Mr. Stonecipher doesn't have any intention to stand in the way between Ms. Hunt and any kind of investigative organizations, CPS in particular. He would like this case, this motion decided on a very narrow basis, and that's in 7.105.500 paragraph 3, where in order to have a modification or termination of a protective order, the moving party needs to show a substantial change in circumstances such that the respondent will not resume, engage in, or attempt to engage in this case, acts of unlawful harassment. So none of the allegations presented in this motion would give any indication that Miss Hunt would not resume harassing my client. And for that reason, we just like this denied, and Miss Hunt can, pursue her son's interests in proper forum. Further, we'd like an order for attorney fees because they're allowed under the statute. And we're also interested in moving to seal the record because of these inflammatory statements that Ms. Hunt is making about Mr. Stonecipher, including asserting that she just asserted in court that he has done these things, that he and two accomplishments have indeed sexually abused her child. These are horrific and inflammatory allegations, and they should not be out there in a public record. My client is a teacher and he works with young students. He hasn't had any interaction with Miss Hunt's student since June of 2023. It's not to say that, there's any time bar to the allegations that she's bringing forward, but it's just that these just seem kind of unsupported allegations and a lot of hearsay in her submissions. Thank you.
So ma'am, I'll give you the final word here. Anything?
So, yes, so my son started sexually
Okay,
acting.
so ma'am, and I don't want, the
Okay.
issue here
Okay.
is whether or not this order needs to be adjusted. And remember, he's the
Okay.
petitioner, you're the respondent in that order. And so with regard to, allegations that you
Okay.
reference in yours and was just referenced by Mr. Clark, that's going to be heard by and decided by somebody else, not me.
Okay,
And so the only issue here is whether or not this order needs to be changed.
okay. So I've been counseled that anyone that I talk to that could then take my information and communicate it to Mr. Stonecipher, that could be considered third-party contact.
Okay.
And I'm trying to avoid being in violation of the protection order or prosecuted for participating in a full investigation, me and my son being able to be involved.
Okay, well, I don't, as I kind of hinted earlier, I don't think there's anything in this order that prevents you from participating in any sort of investigation or anything like that. I'm not sure. Again, I'm not sure what you were told, but based on what you have said and what you have put in your paperwork that was filed, I don't see that there's any reason to adjust the no contact order at this time. It's going to
Okay.
remain in place.
Okay,
With regard to, so your request to adjust the no contact order will be denied.
okay,
With regard to Mr. Clark's comments about sealing the record, I don't think that, I think I'm going to need a formal motion on that with briefing, because typically we don't do that. And so if you want that, you're going to have to bring a motion on that with a brief as to how we can do that, because people file, all kinds of stuff in these sorts of hearings. And, we just don't, absent compelling circumstances, we don't seal records. And so, or court files. So you're going to have to, again, if you wish to do that, Mr. Clark, on behalf of Mr. Stonecipher, you'll have to, brief that. And I'm also given, I'm gonna at this point, I'm gonna deny the request for attorney's fees.
Under what basis, Your Honor?
What do you mean?
Did you make any findings that would support that ruling?
Which ruling?
Denying attorney fees at this time?
I think it's just, I think it's discretionary, and I'm choosing not to do it.
Okay, thank you.
Sure, you're free to go, ma'am. No contact order remained in place. And Mr. Clark and Mr. Stonecipher, you're free to go also.
Your Honor, one more question. Does he still need to be served the paperwork? My understanding is he needs served the paperwork
What's that? No,
that I
we-
originally filed.
We've handled it here today, so this hearing is over. The no contact order remains in place.
Okay,
You may go.